Good morning, everyone. Good afternoon, good evening, depending on which part of the world you're joining us from. Thank you for joining us on the third in the webinar series of on space sustainability. As we all know, space sustainability is not just a buzzword. It has become critical for reliable space applications on Earth. And of course, access to space and space operations ensure that we continue to derive benefits from down here on Earth. So I'm happy that we're able to have this webinar after the launch and the public presentation of the volume 1 of the McGill Manual on governance of military activities. And we have a very stellar panel here who are going to kind of lead the discussion on governing of military activities in space. So I welcome everybody, and it's going to be a very informative and educative program. So I wish you the best in the deliberations and the discussions. So I hand over to Professor Jaku, who is going to moderate the event. Welcome once again. Thank you.
Thank you very much.
This meeting is being recorded.
Thank you very much, Mr. Offing. Hello and greetings from beautiful Montreal in Canada. On behalf of McGill University, it's with great pleasure that I welcome you all to a webinar on the governance of military space activities, the McGill Manual. My name is Ram Jaku. I'm a professor at the Faculty of Law at McGill University here in Montreal. I'm also the project director of the Milamos project. I have the honor to serve as the moderator of this webinar. First of all, I would like to formally recognize the unique and enduring relationship that exists between indigenous peoples and their traditional territories in Canada. McGill University is located on land which has long served as a site of meeting and exchange among indigenous people. McGill University honors, recognizes, and respects these nations as the traditional stewards of the lands and the waters on which we meet today. This statement befits very well with the purpose of this webinar, which is a meeting of people from around the world. All of us are virtually meeting in order to exchange ideas covering some legal aspects of military space activities, focusing mainly on McGill Manual. The manual is a product of McGill University's Milamos project, and Milamos refers to McGill Manual on international law applicable to military uses of outer space. This webinar is organized by African Space Leadership Institute in collaboration with our Institute of Air and Space Law. Since its inception in 1951, the Institute of Air and Space Law has been the world's leading educational institution in the fields of air law and space law. It has produced more than 1,200 graduates from more than 120 countries. For the last 4 decades, the Institute has been involved in pioneering research and outreach activities related to military uses of outer space. Currently, we are working on 3 major space law-related research projects. They are the drafting of the McGill Manual, secondly, the McGill Encyclopedia of International Space Law, and thirdly, the study of law and policy related to space technologies for sustainable development goals in South Asian countries. At the Institute, we are delighted to receive an invitation from Mr. Offing for collaboration to organize this webinar with the African Space Leadership Institute. I take this opportunity to congratulate to the leadership of ASLI for this timely effort in creating this network of people. And I quote from their site, this is the group of passionate individuals who understand the value proposition of space technology and science in addressing socio-economic environment challenges in Africa. This is a noble cause. We offer a hand of friendship and collaboration with you, Mr. Afin. Africa is on the move in space sector. In addition to the creation of several national space agencies, we welcome the establishment of African Space Agency. As you can imagine, the subject of governance of military space activity is very broad and complex. We will only focus on McGill Manual as a window into in the context of international regulation of military space activities. More specifically, we will provide an overview of the manual and describe some of the findings of our 6 years of advanced research. Beside me, the panel consists of my colleagues. They are Mr. Bar Goswami, Mr. David Chen, Professor Satsuko Aoki, and Professor Stephen Freeland. I will introduce them later on. Each of them will present in about 12-14 minutes their thoughts on a couple of topics that are included in the McGill Manual. After their individual presentation, we will have a Q&A session. Please post your questions on chat box. Mr. Nishit Mishra, who is a research assistant with the Milamos project, will monitor the chat box and present some of key and relevant questions or responses by the panelists. I will start my brief overview of the manual. Bar, could you show these slides, please? Thank you very much, Bar. Next, please. What is the need of this manual? What is the rationale behind it? So I have a few points to mention. We all know the international community recognizes the common interest of all mankind in the progress of the exploration and use of outer space for peaceful purposes. We already know that all countries heavily depend on outer space for their growing economic, commercial, social, scientific, ecological security needs. However, outer space is becoming congested, contested, and competitive. Consequently, international peace and security are being threatened. I believe the conflicts and wars in space would cause unimaginable damage to all countries. I'm of the opinion that outer space is not a lawless domain. Conflicts and wars in space are not inevitable. They can and must be avoided with the appropriate international rules-based global order. The sources of law, as you may know, applicable to all users of outer space are diverse. Therefore, clarification of existing international law, that's lex lata, is vital for understanding, implementing, identifying gaps, and making necessary improvements in the international rules-based global order for outer space. Next, please. So what is the uniqueness of the manual, McGill Manual? McGill Manual aims to objectively clarify existing international law, that's lex lata, applicable to military use of outer space in time of peace, including challenges to peace. As you may know, international law governs military operations twice. First, before the start of armed conflict, that is in Latin is called jus ad bellum, and secondly, during the period of armed conflict, that's called jus in bello. So we are concentrating mainly on jus ad bellum. And McGill Manual is essentially with the clarification of the existing law. That means it aims at the discovery of law, not at the invention of law. So we are not looking at lex defenda. So we are concentrating mainly on lex lata. McGill Manual is a collective product of about 100 legal and technical experts, research assistants, reviewers, state observers from various countries and sectors, which include governments, military, academia, and civil society. All of us work in our personal capacities. The process we are following is very democratic, consensus-based, independent, neutral, objective, and transparent, and international. We use only evidence-based information from primary sources of law and official opinions. We do not use the views of authors or professors or publicists. We have already published volume 1, as was mentioned earlier, which is available free of charge. We are working on translating this English text into 7 languages, which will be made available soon. Volume 2, which contains commentaries, will be published by Springer in late 2023. It will be an open access publication and will be available for purchase at a significantly reduced price and could also be downloadable free of charge. McGill Manual is designed to be useful to government officials, policymakers, military, and commercial space operators, academics, students, and civil society in general. We expect the manual to contribute to international debate on military uses of outer space. So we invite our friends in Africa to have a look at the manual and use it in their deliberations, and also make presentations and make their views heard at international fora, which addresses this issue of military uses of outer space, also sustainable development. With that overview, I move to our first panelist. It will be Mr. Bar Goswami. Mr. Goswami is also Doctoral Fellow at the Institute of Air and Space Law here at McGill. He is a research coordinator and co-editor of a McGill Manual Volume 2. He has authored several papers on various aspects of space law. Bar, over to you.
Thank you for a very kind introduction, and thank you, Etim and the ASLI for inviting us and collaborating in arranging and organizing this webinar. I might be just a bit distracted because I'm also the host of the meeting, so I have to enter the participants that are in the waiting room. So I'll just try my best doing a couple of things here. So I think Professor Jaco gave a very great overview of as to the rationale and goals of the project, and as to why we started the project about 5-6 years ago, and what we have been doing in terms of up until Volume 1, and now what we are doing for publishing in Volume 2. So I'll just give a brief first on research methodology as to what we have followed in terms of arriving at the 52 rules that you now see in Volume 1 of the published manual. And you will also see the same methodology or similar methodology in the upcoming Volume 2, which relates on commentaries, which are on the 52 Statement of Law. So the focus of Milamos, or the McGill Manual, as we call it now, is on lex lata. What is lex lata? Lex lata, in simpler terms, is what the law is. What is the existing law? So our exercise has not been to find or give an opinion about what the law should be or what the law ought to be. We have only focused on what the current state of law is on a subject matter that is relevant to specifically military users, but also generally to actors in outer space. So our focus, one of the key focuses of the manual, and if I may call it the ethos, has been to find a lex lata statement, a statement of law that is reflective of what the law is at the moment and not what it should be or give an opinion about it. And how did we come about determining lex lata or what the law is? We have been very meticulous and we have worked very hard our way in being objective and being not subjective in the sense that we are not relying on opinions of academicians. We are only relying on primary sources. And we have, in the entirety of the manual, volume 1 and volume 2, have not referred to have not derived opinions or a statement of law based on a subjective element, such as the opinion of somebody or what we felt was right. It has been derived only and only on the basis of objectivity, on the basis of evidence that we could find in the primary sources that exist in the realm of academia, government documents, and primary sources of international law. Another focus that we have been very loyal to has been that the 52 statement of law that you now see in McGill Manual Volume 1 represent consensus. So we have a team of about 40 group of experts, and each of those experts had to sign off and say that, yes, we do agree that this particular statement of law represents lex lata or what the law is. So all the statements that you see in the now published manual, 52 statements of law on.
Let me know if there's this track.
I'm sorry, could I ask the participants to mute? Yeah. So the 52 statements now represent the consensus that everybody has agreed on a topic of relevance, and the 52 statements represent that consensus. Another focus that we also, since the very start of the Milamos project and the McGill Manual, has been the engagement of diverse legal and technical experts who represent and have presented their input from across the domains of international law. It includes international space law, telecommunication law, and even humanitarian law, military, and they represent different backgrounds as well, from military and non-military backgrounds, from governmental and non-governmental background, private entities, and even international organizations. So these four key focuses have been at the core of arriving at the 52 rules that we now have published in McGill Manual 1. Yeah. So how did we go about doing that being the philosophy or ethos of what the McGill Manual or Milamos project represented, but how did we come about in doing that effectually? So the process started with a first draft of the rules statement and complementing commentary to the rules statement, which was circulated to the group of experts online for a review. It was then the feedback was received by the assigned expert who had drafted the commentary, and the assigned expert would then take the feedback and comments and revise the commentary and the rule statement in preparation for the plenary or the workshop that we have held across the globe. And we have had about 8 to 9 Milamos workshop. So the circulated online version would then be revised by the assigned expert and tabled at the plenary. And in almost all cases for 52 rules, it was never adopted in the first session. It was always that we received some feedback on it. We received intense reviews and revisions, and based on discussion, it was further revised. Once it is further revised, and it all is contextual and dependent on what the rule is, what the rule commentary said, it goes through the same cycle. It went through the same cycle over and over again until at the plenary, at the workshop, all of the experts could arrive and say that, yes, this is the distilled concrete statement of law that all of us can agree to. So once that was agreed, from the plenary, it moves to the editorial committee, and the editorial committee would make further not substantial, but editorial changes to the rule statement, maybe sometimes, but mostly only on the. Once the revisions and editorial changes were completed, there would again be an adoption, or there was again an adoption of the rules with consensus by the editorial committee. Once that process got completed at the editorial committee, we moved on to refining the commentary at the McGill team, and now we are working as a co-editors group for Volume 2, and we are refining commentaries at the moment. And most of the commentaries also now have been, there is a process in between as well, where we send the commentaries to external experts who have not been part of the Milamos process, but are renowned global space law experts. We send it out to them for their review, and every rule almost has been through multiple experts. And so we have tried to maintain everything that we had in terms of set out as a goal and as philosophy for the McGill Manual, in terms of remaining objective, producing a product, a consensus-based product, and representing only lex lata, and engaging as diverse group and as diverse opinions as possible. So it also is important to understand what then is the application of the McGill Manual. So what activities, or what is in a sense the scope of the McGill Manual? So since the very start of the Milamos project, we drew a line in terms of its applicability, that the McGill Manual will only apply or only deal with subjects and commentaries and the rule statement that we produce, primarily to peacetime space activities, and also in times posing challenges to peace. The McGill Manual does not apply or extend its scope to times of armed conflict. We do not deal with the subject matter of armed conflict, and the 52 rules, as you see in the now published manual, and the following commentaries that you will read, do not deal with situations or times of armed conflict. It purely, strictly only applies, there's a very strict delimitation that it only applies to peacetime and in times posing challenges to peace. And however, that is not to say that certain principles and examples from international humanitarian law have not been referred to or have not been borrowed as a guiding beacon, if one may say, to further clarify the scope of application of the McGill Manual. So we have not, it would not be fair to say that we haven't at all touched the principles of international humanitarian law, but we haven't dealt with the subject in a sense that we are talking about conflict situations. We may have referred to principles just to further clarify the scope of the application of the manual. So I'll just give a brief idea. It's very difficult to comprehensively deal with specific rules, but I think the panel, as a panel, we decided that we should give a glimpse of what the commentaries and what the rules entail, and what that would be a good takeaway for all the participants. So I'll just give a glimpse of 3 rules. For example, the rule 101 in the now published manual is a rule on space activity. So in most of the rules, we see a pattern that there are reiterations. I'm sorry, I'm getting some noise. I'll just try to mute the participant. Never mind. So you'll almost see a pattern in terms of the rules and the commentaries, that there are some reiterations. In commentaries, there are some clarifications. And then in the commentary itself, we present the gray areas, or what we call ongoing issues or future challenges. So in Rule 101, if we were to read it more carefully, so the reiteration is that space activities are activities in the exploration and use of Earth, which basically is export or import from the Outer Space Treaty and many of the other international space law documents. So we are reaffirming that activities in the exploration and use of outer space, including the moon and the celestial bodies, form the bigger universe of space activities. And then in the clarification part of it, we define for the purposes of the manual that space activities are activities that have or be intended to have direct effect either in outer space, on the operation of space infrastructure, or from outer space to another domain. And so could I ask the participants to mute themselves? There's a lot of noise that is incoming. Yeah. So in terms of clarification, what then do we mean by space activity? Because space activities serves as the foundation of many of the other rules, for example, national space activities, because the term remains the same. For example, military space activity, even to the extent that application of international law to space activities then also is a rule. And we do need to know what international law applies to what. That is space activity. Also, it then comes down to as an implication as the responsibility for international responsibility for conducting space activity. So space activity rule 101 serves as a foundational rule for many other rules. And we have been very careful in drafting this definition as to what it means or what it implies, and have also identified the ongoing issues and future challenges. So what then are the direct effects? So direct effects is anything that causes an effect in outer space or through outer space or from outer space to different domains. So what we include in space activities are three domains or the three space infrastructure, which is space-based infrastructure, which is what we call the space segment. Then there is the ground segment where we communicate with the space segment. And then, of course, what we communicate with. So any effect, any creation of an effect by an activity in one of the three space infrastructure would deem to be or would understood to be a space activity. In outer space or through outer space by the means of cyber activities, then it would also be considered a space activity. Now, moving on to what military space activity then could mean, it really then comes down to any space effect that has a military character would be understood for the purpose of the manual as military space activities. And we have come about three criteria in determining what constitutes a military character. And the three criteria are the actor involved in the activity can be understood or is from a military background or is a military personnel, then it is a likely case that the activity could be a military activity. But again, as a caveat, it's not, these three criteria don't work in isolation. They work in combination. So it would hardly ever be the case that just because an actor is from a military background, the entire activity could be termed military activity. It usually is a combination of the three criteria where actor, aims of the activity, effects of the activity are to be taken into consideration, determining the military character of the activity. So what then are the gray areas or future and ongoing challenges? So because we don't have delimitation in between airspace and outer space, it sometimes becomes, especially the areas in the gray zone where we don't yet know if it's outer space yet or we are still in the airspace, it becomes very difficult to sometimes identify what constitutes as space activities and what constitutes maybe not a space activity or just an aviation activity or earth space activity. So in absence of a clear delimitation between airspace and outer space, it presents a challenge in determining space activities sometimes. One of the challenges also is the categorization of suborbital flights as to whether they constitute a space activity or not. And similarly, with the sounding rockets, we have this opinion that sorry, I'm just muting.
But is it possible to mute everybody? There's some way.
Yeah, I have to do one by one, so that's what I'm managing. I'm sorry.
Bayar, I've sent you instructions on how to do that for everyone. Please check your chat.
Oh, all right. Okay, so I've muted everyone. All right. Sorry for the disturbance. All right. So now I'll deal with another one of. I'll try to give a glimpse of one of the other rules in the manual, which is also equally important, which is the rule on peaceful purposes. We have come up with a rule for peaceful purposes, which has about 4 paragraphs and 4 sentences. And again, there are some reiterations, there are some clarifications, and then there are identification of gray areas, which we call the ongoing issue, the future challenges. So the reiterations really are that the international space law recognizes the common interests of humankind in the progress of exploration and use of outer space, and the space activities have to be conducted in the common interest of all humankind. Again, one of the more fundamental reiteration is that the moon and the celestial bodies have to be used for exclusively peaceful purposes, which also prohibits use or testing of any of the weapons or any military maneuvers, installations, bases, all of those kind of activities on the celestial bodies. And again, there is one more reiteration, which again comes from the Outer Space Treaty, that while there is a 2-tier approach in Outer Space Treaty to deal with military activities and the prohibition on the celestial bodies, the use of military personnel for peaceful purposes, such as scientific research, is not prohibited. So these are the reiterations. What are the clarifications in the commentary that you will find once we publish that? So one of the clarification is that military character of space activity does not alter applicable laws. So just because an activity is characterized as of military character or is a military space activity, that does not necessarily mean that the principles or the rules of international space law or international law generally seem to apply differently unless otherwise explicitly provided by the treaty or the relevant law. So that is one of the findings that is really crucial, that international space law generally does not distinguish between space activities and military space activity and applies similarly to both activities unless it's explicitly mentioned in the Outer Space Treaty or international space law document. Again, we have tried to be hands-on, and we have tried to provide a clarification as to what is meant by peaceful purposes. And it has been a very challenging task. And general finding, I can't really go in too much detail because of time limitations, but a general finding is that the term peaceful purposes usually would entail in the group of experts' opinion that, of course, it has to be non-aggressive, as was agreed by the states, but all comprehensive or all encompassing reading of Outer Space Treaty and international space law documents needs to be pulled in at this moment to really understood what peaceful purposes means. So anytime peaceful purposes is implied, the group of experts have arrived at the opinion that it has to bear, the actor has to bear in mind the general principles of benefit and interest of all humankind, maintaining international peace and security, and promoting international cooperation and understanding, cooperation and mutual assistance, and even due regard for corresponding interests of other state parties to Outer Space Treaty and generally otherwise states involved in space activities. And each of these terms that I'm mentioning, whether it's cooperation and mutual assistance, due regard, international peace and security, most of benefit and interest of all mankind, most of them do find a lot of detailed commentary or a separate rule for themselves in the manual itself. So while we do say that peaceful purposes entails this, but it may not be the case that we are comprehensively able to deal with that entirely in this one commentary, but the entirety of the McGill Manual and the commentary works hand in hand, and they have to be read together. So many of these rules, such as or principles such as cooperation and mutual assistance and due regard, have separate rules to themselves and commentary following them. So anytime peaceful purpose is being read or its commentary is being read, one would also have to take into consideration the affiliated commentary or the cross-referring commentaries. So what are the gray areas? Again, there are many, but one of them is that there are certain activities that we have been able to identify that exist, that are explicitly not prohibited, but appear to contradict or somehow conflict with the object and purpose of the Outer Space Treaty, or how contextually international space law is situated. And such activities continue to pose challenge and threat to the peaceful uses of outer space and peaceful exploration of outer space, which again includes the common interest of all humankind. So these are some findings that we have been able to identify. And of course, I can't do justice in just 12 minutes. And that's a challenge almost all the panelists are facing in this panel today. But then we are trying to give a glimpse and an idea of where we are situated at the moment. So that would conclude my part of the presentation. Over to you, Professor Jaku.
Thank you very much, Bart, for re-emphasizing the uniqueness of the manual. And I believe as to better understand law, one must know lawmaking process. So that is why I think the process you have re-emphasized, explained, it's very important to better understand the content, the scope, the nature of the manual. Secondly, I'm happy you underline the fundamental issues which we have to deal with respect to the basic concepts. These concepts, these definitions, or these terms are not defined in specific treaty. And we worked very hard to try to figure out, again, based on law, based on state practice, what they really mean. The concept you mentioned, military space activation, and you know, or all of us know how challenging it was to look at what is a launching state is. But these are the, I would say, foundations to understand the law as it applies to military uses of outer space. Again, thank you very much. We go to our next speaker, who's Mr. David Chen. Mr. Chen is a doctoral candidate at Bond University in Australia. He's a managing editor of the Milamos Project and also co-editor of the McGill Manual Volume 2. David has been had various positions at the Institute of Air and Space Law at McGill University and published numerous articles in air law and space law. David, over to you.
Thank you for the kind introduction, Professor Jaku. So I'd like to take the opportunity to express my personal appreciation to the African Space Leadership Institute for their initiative and also for their kind invitation. So in my presentation, I'll take time to focus on two vital aspects of international space law, which are fundamental to ensuring the safety, security, and also the sustainability of outer space. And namely, these are the freedom, sorry, Bayar, can you go to my slide?
I'm sorry.
These are, yep, no problem. Yeah, so these are the freedom of exploration and use, as well as issues related to responsibility and the liability of states relevant to the conduct of space activities. And as you'll see on the slides, you know, these two major issues, the freedom of exploration and use and responsibility and liability of states, they are touched on by several rules and chapters of the McGill Manual. So if you want me to summarize my message in one line, it will be this: there is freedom to explore and use outer space, but that freedom is subject to various conditions and restrictions. So we can trace the history of the freedom of exploration and use back to the early days of the space age. Shortly after the launch of Sputnik, the then ad hoc committee on the peaceful use of outer space noted that space launches and space flight established, quote, generally accepted rule that outer space is, on conditions of equality, freely available for exploration and use by all in accordance with existing or future international law agreements, end quote. And this principle was stipulated in the 1963 Declaration of Legal Principles, as well as reiterated in now Article 1 of the Outer Space Treaty. So it must be noted that the freedom to use and explore outer space includes the freedom to use and explore the moon, including celestial bodies. And this is a freedom to be enjoyed by all states, right? Indeed, after the adoption of the Outer Space Treaty, the US representative said that the Outer Space Treaty makes it clear that outer space, quote, are open not just to the big powers or the first arrivals, but shall be available to all, now and in the future. It was said that this is a strong safeguard of the interests of those states which have, at the present time, little or no active space program of their own, end quote. So the Outer Space Treaty makes it very clear that irrespective of the degree of development, all states are entitled to benefit from space exploration and use, and that at least in principle, there shall be equal opportunities for all to partake in such exploration and use. Freedom of exploration use is captured in 1118 of the manual. Here I'll just take a few moments to explore what the words mean, right? So the verb to explore, it may be commonly understood as conducting or an investigation or discovery of something or an area that's relatively unknown or unexamined. And so are we recording? Right. Okay. So we've seen the practice of states that there's been a variety of uses in outer space, including to support applications such as navigation, timing, positioning, the facilitation of communication, weather monitoring, disaster relief, as well as the use of outer space for observation of distant galaxies, as well as we've seen space tourism. Now, on the military and strategic front, we also see the use of outer space for the conduct of reconnaissance, surveillance, arms control monitoring. We're also aware of space applications that are used to guide missiles and drones to target terrestrial military objectives. And unfortunately, we've also seen space being used to test anti-satellite weapons, as well as other anti-satellite capabilities. These are all examples of use. The next slide, please. So, as I said, the freedom to use and explore outer space is not absolute, right? For this is subject to several conditions, some of which are explicitly mentioned in the Outer Space Treaty, some of which are captured in that phrase in accordance with international law. Right? So within the Outer Space Treaty itself, you can see specific limitations placed on freedom. Article 2 prohibits national appropriation. Article 4 prohibits states from placing in orbit, installing on celestial bodies, or stationing nuclear or other weapons of mass destruction. Article 4 also specific to the moon and other celestial bodies prohibits the establishment of military bases, installations, and fortifications. And Article 9, as my colleague Setsuko will discuss more in detail, requires that states undertake activities guided by the principle of cooperation and mutual assistance, as well as have due regard to the interests of our states. Right? So most importantly, the Outer Space Treaty provides that states must conduct their exploration and use of outer space in accordance with international law. As we know, outer space, under international law, states are sovereign and they enjoy the freedom to act. And such freedom includes the freedom to use and explore outer space. However, being sovereign does not mean you have absolute rights and absolute freedoms. It also means that you're subject to certain responsibilities and liabilities. Specifically, in the conduct of space activities, states are subject to responsibility and liabilities arising from international space law, as well as general international law. Next slide, please. And I will address the liabilities and responsibilities arising from international space law, as this is quite a unique legal regime. And the McGill Manual that my colleagues and I have worked tirelessly on the last couple of years to clarify. So our aim is to clarify many legal issues and address challenges that to date have not been fully understood. As I've listed here, there are specific responsibilities and obligations incumbent on states attached to that freedom to explore and use outer space. And these are detailed under the Outer Space Treaty. These include the obligation to, for example, rescue and render assistance to astronauts, to notify the UN Secretary General and the international community of the so-called nature, conduct, locations, and results of space activities. And there's also the responsibility to conduct consultation in case of potential harmful interference with the activities of the states. So in the interest of time, I'll just focus on three responsibilities, namely the responsibility for national space activities, the responsibility to authorize and supervise activities of non-governmental entities, as well as liability arising from damage caused by a space object. Next slide, please. So you see, space law provides that states are internationally responsible for national space activities. This means that a state is responsible for activities that are conducted by governmental agencies as well as non-governmental entities such as private citizens, corporations, or indeed scientific research institution. So for instance, imagine a new space startup may be eager to harness space technology to improve telecommunications in remote areas, and that startup launches dozens of satellites into orbit from state A. If these satellites collide with other satellites in space, in orbit, or cause interference with the activities out of the states, state A would be responsible, whether or not state A has knowledge of such activity of the startup. So it's very important that states must ensure that national activities, including activities conducted by non-governmental entities, are in compliance with the provisions of the Outer Space Treaty, and that activities conducted by non-governmental entities are authorized and supervised. So in practice, as we've seen, this is done through the adoption of national space legislation. Indeed, through various capacity building initiatives, the United Nations has urged states to adopt measures to ensure that states conduct their activities in accordance with international law and to strengthen the safety, security, and sustainability of outer space. There are other multilateral and regional efforts, such as the National Space Legislation Initiative of the Asia Pacific Regional Space Agency Forum, which are going a long way to promote the drafting and implementation of national space legislation. And if I may suggest, this is perhaps something that space agencies as well as space stakeholders in Africa should devote attention to. Right? The adoption of national space legislation will provide greater legal certainty and will also in turn build business confidence and foster the development of domestic space industry, which we have seen across the globe and produces tremendous socio-economic effects. In terms of liability, again, space law is unique in that liability specifically arises for damage caused by a space object. So under Article 7 of the Outer Space Treaty, the state that launches or procures the launch or from whose territory or facility a space object is launched is internationally liable for damage caused by a space object. And the Liability Convention established is a two-tiered approach to liability. But what is the meaning of damage? Now, the Liability Convention has a definition of damage, and specifically that refers to the loss of life, personal injury, that also includes impairment of health or loss or damage to property of states and persons. In the commentaries to the McGill Manual, we discuss more closely, we looked at closely the discussions that were had at the drafting of the Liability Convention, and it was clear that, for instance, both physical and non-physical damage were considered. For instance, what damage would not only be damage caused by physical contact or collision with a space object, but may also include non-physical damage caused by such, for example, jamming or interference with the transmission signals. Another issue that is captured in the commentary is the link between damage causing effect and the damage itself. Now, looking at the case law under international jurisprudence, it's generally understood that damage should not be too remote or indirect or uncertain to be appraised. That comes from the Trell smelter case. Such discussions and analysis are what makes the McGill Manual valuable and contribute to a better understanding of the international norms and rules that are applicable to space activities. Next slide, please. So moving on to the topic of responsibility and liability arising from general international law. Again, remember, even though there's freedom to explore and use outer space, this freedom is subject to applicable rules of international law, which may be provisions of the UN Charter, and maybe also other bodies of law, such as the law on the responsibility of states for internationally wrongful acts. For instance, basic international law provides that whenever there's a breach of an international obligation, a state will be held internationally responsible. Now, such a breach of an international obligation may, for instance, as I've outlined earlier, failing to assure that national space activities are in conformity with Outer Space Treaty. And beyond the law of space responsibility, there may be other bodies of law that may have, may further restrict or condition that freedom of exploration and use. So as we know, there's the issue of overcrowding of orbits, and space debris is a matter of great concern to the international community. So on Earth, there's a great body of environmental law principles that have been developed, such as the principle of transboundary harm, the precautionary principle. Now the question is, to what extent and how would such principles be applicable to outer space? And a field of my personal interest is this human rights law, right? So on Earth, we know that states have the obligation to uphold and arguably advance human rights. And according to jurisprudence, if international human rights courts and tribunals, such responsibility to safeguard human rights are also applicable extraterritorially. If we are to consider the potential impact of a whole host of space activities on human rights, what are the responsibilities and liabilities of states that may impinge on their freedom of exploration and use? Of course, this is a very brief overview and doesn't really do justice to responsibility and liabilities, but I hope I leave you with some food for thought. And I hope with together with my colleagues, our hope is that with the publication of the McGill Manual and such outreach events, we make you, the space leaders and space stakeholders of Africa and beyond, think more about the present and future challenges and opportunities in outer space. So, thank you.
Thank you very much, David. The two key points I noticed, which should be kept in mind, is the freedom to explore and use of outer space is not absolute. That is absolutely true. Secondly, which I deduct from your presentation, is the sovereignty is under international law. And also you highlighted the uniqueness of space law with respect to responsibility. These are very important key points. Again, thank you very much for your presentation. We go to our third speaker, is Professor Satsuko Aoki. She's a professor of law at Keio University School of Law in Japan. She's a core legal expert and co-editor of Volume 2, dealing with the commentaries of McGill Manual. She holds a Doctor of Civil Law degree from McGill University, and we are very proud of her being the graduate of our institute. She's one of the top space law experts in the world. She served as the chair of the legal subcommittee of the United Nations Committee on Peaceful Uses of Outer Space. Satsuko, over to you.
Oh, Professor Jaku, thank you very much. Very, very kind introduction. So following my colleague, David, I'd like to showcase 3 rules among 52 Milamos rules. So Bayer, could you start my PowerPoint, please? Yes. Oh, thank you very much. And before that, allow me to express our sincere gratitude to the African Space Leadership Institute for hosting this wonderful webinar. And I believe and hope that African stakeholders and us McGill team will have the opportunity to work together in the near future. I'll pick up 3 rules, that is due regard, interference, and the right of self-defense. Next slide, please. Yes, thank you. Yeah. Through the explanation of 3 rules, I'd like to convey one message, that is, all Miramos rules are the existing international law rules found by the joint research of the experts participating in the Miramos project. No rules are desirable or ideal international law rules for the peaceful purposes of outer space. This slide shows 5 types of existing international law rules in which specific Miramos rules can be categorized. This may be a little bit of overlapping with that already Bayar explained. But so, well, I wouldn't go into detail, but to explain that 3 rules from now on, well, I need this from, well, slightly different perspective. So, well, bear with me a little bit. Yeah. And this categorization is, well, big, of course, not an authentic one. I made it solely for the purpose of highlighting the origin and the characteristics of the 3 rules to speak today. Type A rules are substantially the reiteration of a provision of the existing treaties, such as the UN Treaties on Outer Space, ITU Constitution, and the UN Charter. About half of the Miramos rules belong to this category, according to my calculation. Type B rules show some modification or deviation from the said treaties while reflecting existing international law, and less than 10 rules belong to this category. Type C rules are concrete rules on a military space activity not found in the UN treaties on outer space or other related treaties, but found from customary international law. About 15 Miramos rules belong to this category. Type D rules only state that a certain military space activity must be conducted in accordance with international law. 5 rules belong to this category. And finally, type E. This finding is that there is no established rules as of today. 2 rules could be categorized in type E rule. So next slide, please. Oh, thank you. Rule 120 of the Miramos provides that in conduct of space activities, including military space activities, states shall be guided by the principle of cooperation and mutual assistance and shall conduct such activities with due regard to the corresponding interests of all other states. This rule is substantially the reiteration of the first sentence of Article 9 of the Outer Space Treaty. So this is type A rule. Next slide, please. As the Outer Space Treaty doesn't state the meaning and the standard of due regard, these have to be found in customary international law and also the decisions of the International Court of Justice, other international tribunals, and also from the hours of arbitration. Due regard is, well, based on this research, is the obligation of self-restraint in exercising space activities. And due regard is the balancing mechanism between states in exercising the identical rights, different kinds of rights, etc., in overlapping place or orbit. Oh, sorry, wait, the next slide, please. Oh, yes, this one, thank you. And, well, it is the obligation of a state to refrain from causing unjustifiable interference with the rights of other states' space activities. Also, the standard of due regard would be determined by the specific circumstances and the nature of rights exercised by states on a case-by-case basis. So when we study if a destructive ASAT test could be done with due regard to the corresponding interests of all other states, the following factors, for instance, should be considered. the altitude where a test is conducted, if it is 220 kilometer or congested 800 kilometer, or to which space object, if it is to a CubeSat or to a 2-ton military reconnaissance satellite, or if a test is conducted near a manned space station. Such specific circumstances should be carefully analyzed. Next slide, please. Yes. And we're already next rule. Next, Rule 139 sets forth that states shall refrain from intentionally causing either physical or non-physical harmful interference with space activities of another state. That is a type C rule found from customary international law, including the elements of the third and fourth sentences of Article 9 of the Outer Space Treaty. Some of other rules of Chapter 6 that focuses on interference are either substantially the reiteration of the ITU Constitution or the findings from customary international law. Next slide, please. Yes. Then the scope, well, then the essence of the Milamos rules on harmful interference is as follows. The first, intentional harmful interference, physical or non-physical, is not categorically or comprehensively prohibited. And second, states are obligated to ensure radio stations within their jurisdiction will not cause harmful interference to the authorized radio services and the communications of other actors. But three, military radio installations are in general exempted from such prohibition. However, a certain prohibition or qualification is found in the Milamos rules on some intentional and harmful non-physical interferences, such as jamming, spoofing, and interfering with telemetry tracking and command operations. Next slide, please. Yeah, due to the time restraint already, third rule. So the last one, well, which I would cover is the right of self-defense. Well, this slide shows the text of the rule 152, the right of self-defense. This rule consists of, well, interestingly, consists of two paragraphs. First paragraph is a part of Article 51 of the UN Charter, which states the rights of individual or collective self-defense. So this rule, well, this paragraph is to reconfirm that there also exists the right of self-defense on military space activities in space, in outer space, from outer space, or directed or through toward outer space. But well, while it is reconfirmed, it may not be unconditional. Paragraph 2 is very important in this regard. It states that physical and legal characteristics of outer space must be taken into account in any exercise of a state's right of self-defense. Next slide, please. So, by the way, the right of self-defense may be possible if an armed attack occurs in or from or is directed through or towards outer space. The precise scope has to be determined with the help of the definition of military space activities. That part was already covered by Bayer. So it is, well, that armed attack should come from outer space to outer space, or outer space to other domain, including cyberspace, or outer space to the Earth, as well as from the Earth to outer space. So the last slide, please. Thank you. So finally, well, let me contemplate the concrete conditions of the right of self-defense concerning space activities, military space activities in, from, and to outer space. Well, circumstance precluding wrongfulness to resort to use of force is an armed attack by another state. And precise implication of armed attack under this rule should be discussed, well, internationally from now on. And the resort to use of force as exercising the right to self-defense has to meet the necessity and proportionality conditions established in customary international law. As for procedural rules, as stated in the UN Charter, well, Article 51, the state shall report immediately to the UN Security Council about measures taken, and the right of self-defense can be exercised only until the time when the UN Security Council takes measures, which is also provided for in the UN Charter. And finally, these conditions, well, the last two conditions, that is very important. This would be the target to clarify, to ensure outer space for the sustainable and peaceful area. These are specific environmental characteristics, including especially space debris and the nature of outer space as international area for which exploration and the use of outer space, well, would be, that is determined as a province of mankind in, well, it's determined and enshrined in Article 1 of the Outer Space Treaty, and also other provisions of international cooperation in Outer Space Treaty. So comprehensively thinking about these issues, well, I hope this manual would be very well helpful to maintain and promote for the area, which would be used only for peaceful purposes. Thank you very much.
Thank you very much, Satsuko. I'm very glad that you reiterated the issue which I alluded to earlier, that the sources of law applicable to military uses of outer space does not come only from space law. There are other sources of law, general international law, telecommunication law, customary international law, UN Charter, and all things. And that has been the challenge for the group. And also that is the beauty of the manual, that it picks up the applicable law from different sources. And I'm also glad to see you have categorized the rules in different types based on the sources. I think that's good. I'm quite happy about the explanation you provided with respect to due regard. Due regard, in essence, means is a balancing of interest of states. And that is a very important rule which must be respected by all spacefaring nations. And also the rule of self-defense is not unconditional. Again, thank you very much for your presentation, which is very useful. Now we go to our last speaker as a Professor Stephen Freeland is a emeritus professor of international law at Western Sydney University and professorial fellow at Bondi University in Australia. He's a core legal expert and co-editor of Volume 1 of McGill Manual. He's a leading authority in space law in the world. Currently, he serves as the vice chair of the working group on legal aspects of space research activities of the United Nations Committee on Peaceful Uses of Outer Space. Stephen, over to you, please. You're muted, Stephen. You have to unmute, Stephen.
Thank you. I've done. My apologies. Thank you, Ram. Thank you so much for the invitation. Bayer, if you could flick over to my slide. I only, just one, let's leave it there. I just have one slide to present. And my role here is really to put it all together. You've heard a lot of detail from my dear colleagues. And really my job here is to try to put this in perspective about how you could use the manual, how the manual might assist in the important work that many in the audience and many countries in the African continent are so vital in terms of contributing to, and that is to resolve some of the really, really difficult challenges that we have, amongst them being, of course, the rules governing the military uses. Before I begin, firstly, let me also thank the African Space Leadership Institute so much for the invitation to all of us to present the manual, to talk in your wonderful series on sustainability. Let me also reflect on where I am sitting. Where I'm sitting here in Australia, and it's now 11:15 in the evening here in Sydney, is land that has been lived in by our native Indigenous peoples for about 65,000 years. The Australian Indigenous people are often regarded as the world's first astronomers. And as we move forward, and the McGill Manual is one small part of the process of moving forward to deal with the challenges of space so as to maintain the stability, security, safety, and sustainability of space, there are incredible lessons of humanity, of our place in the whole ecosystem that we must take from our Indigenous people. And so it's important for us to all recognize that. And I support what my dear friend Ram said at the beginning about the Indigenous people of Canada, as it is here in Australia, as it is all over the world. Could you make one click, please, Bea? So we are dealing in a world where space is everywhere. Space is ubiquitous. You and I and every person in the audience, and indeed every person on the planet, is touched by space. Every person on the planet. Every person on the planet in different ways uses space and the technologies that space allows us to harness many times a day. This wonderful event would not be taking place without space technology. Space is everywhere. Space is also incredibly multifaceted. It's about many aspects. It's about politics, and my dear colleagues have touched on that. It's clearly about law and legal frameworks, and that's what we're talking about here today. It's about national security and military aspects, again, what we're talking about today. But it's also about science and about exploration and about culture and about heritage and about history and about our place on this planet and indeed our place in the universe. And the way we move forward with the frameworks to deal with the major challenges and also the major opportunities that space presents will determine the future of humanity. As David said, international human rights are of course impacted by space, but it's even broader than that. It is the future of humanity, not just for us or one generation, but as our Indigenous people here in Australia say, you need to think of the next 7 generations. And that's important. And so with all of these major, what I call big issues in space, we need to reflect on how we find the right frameworks to allow us to maximize the incredible benefits that we can garner from space, but minimize the risks that each of these issues present. Risks of sustainability, risks of aggressive competition, risks of inequities, risks of military uses exceeding what the rules allow for, and many other challenges. Each of these challenges, including the rules governing the military uses of outer space, require a multilateral approach in terms of dialogue, in terms of negotiation and agreement, in terms of establishing frameworks. We at the Millimos project, at the McGill Manual, we are not in any way, shape or form saying this is the answer. This is just one piece of information that we hope will form part of those multilateral dialogues, which are crucial. One more click, please, Bea. What does multilateralism entail? Well, it entails many things. Discussions and dialogues that are, and I use these words deliberately, inclusive, so that everybody has the opportunity to contribute. Cooperative, transparent, respectful. All of those voices that I mentioned at the beginning, from the economists to the military people, to the cultural people, to the scientists, to the government officials, to civil society, all of those voices must be heard. All focuses of the world, all different perspectives, all different histories and cultures must be heard. And Africa and the African continent, and as Ram said, I have the honor of co-chairing a working group at the COPOS legal subcommittee, and the African countries who are member states of COPOS are very active. Africa has a critical role to play as we move forward to meet these challenges, with an eye to maintaining, as I said, the security, safety, stability, and sustainability of space. Africa is incredibly important, and we applaud the African Space Leadership Institute and all of the countries of Africa who are grouped together to form the African Space Agency, who are developing their own national programs, both within their national frameworks, but also collectively. We applaud all of that and encourage your continent and all of the countries of Africa to continue to make sure that they actively contribute and have their voice heard. Next click, please, Bea. So in the McGill Manual, and my colleagues have gone through some of them, we have reaffirmed the lex lata, what the law is. And many of those rules, and I've mentioned a couple of them here, but many of those rules are preconditions to any genuine multilateral discussions that will take place. So I've mentioned 5 here, but I could also add the rule about freedom. I could also add the rule about non-interference. I could also add other rules from the manual. So the manual, in reaffirming the lex lata, also reaffirms that the law is incredibly important as the basis to allow for those multilateral discussions and dialogues to take place, in which Africa has a critical role. Next click, please, Bea. And so let me leave you with this, because we really want to hear from you and hear your questions. You've heard from my colleagues about the detail of many of the rules. Of course, we don't expect all of you to repeat everything that has been said, but hopefully we have given you a feel for the various areas along the whole spectrum of governance regulations about space that the manual seeks to clarify. And therefore, we believe in a humble way that this manual is a tool, because it reaffirms those preconditions for multilateralism. The manual itself is a tool to support those dialogues. It's an aid, a tool for everybody. Certainly, we hope that the African countries will embrace the underlying messages that all of my colleagues have said about how this manual sets out to talk about how the law governs areas in the period leading, prior to an arms conflict. We took a determined decision not to cover the armed conflict phase because, in fact, one of the underlying rationales of the manual is that if we can clarify those rules that exist now in times of peace, and clearly, as we have in the current framework, in times of tension, that clarification, the use of those rules, the resort of those rules to the dialogues and the multilateral conversations will, in and of themselves, lower those risks. That is our hope. Lower those risks and avoid what would be, in a sense, the unthinkable. We understand that the manual is not going to solve problems. We understand that there will be some that will ignore the lex lata that we have striven over the past 6 years to point out. We understand that the big issues of space will require not groups of experts, but states to get together and undertake the proper dialogues in the proper background. We understand that, but we also understand the power of law. And that's what the manual sets out also to achieve. The power that law provides. Too often now, in many of the discussions that are going on about space, the law is not referred to. We talk about responsible behavior, important. We talk about, behaviors in other ways, important. But the law is the framework. The manual, hopefully, in a clear, transparent way, points to those legal principles that will support African countries, support all stakeholders to engage in genuine multilateral dialogue, to resolve these issues, to maximize the benefits for humanity across the entire spectrum of the globe. We need equitable solutions through multilateralism, and in our small, humble, but we feel highly considered way, we feel this manual is a contribution to that process. I hope when you've looked at volume 1 and then got volume 2 when it comes out later in the year, you can reflect on that and use that as a starting point, as a reference tool for those important discussions that must take place with Africa and the African countries, African stakeholders at the forefront. Thank you for your kind attention to all of us. We look forward to your questions, and I pass the floor back to my dear friend, Ram. Thank you, Ram.
Thank you very much, Stephen. You share your wisdom, your philosophy, and you passed on the wisdom of the indigenous people of Australia. I can say the indigenous people of the world. And you have underlined very clearly the need for multilateralism, and also that all voices must be heard because space belongs to everybody. And thank you very much. Okay, before we go to question and answer sessions, I'd like to give a floor to Mr. Ethan Ofeng. Ethan, you have the floor, please.
Thank you, Professor Ramjako. Thank you, all the speakers, for the discussion so far. I think we've had an excellent discussion, and I know a couple of questions have already come in the chat box. But like you mentioned, before we go into that, I just want to say a few things about the African Space Leadership Institute, and to kind of highlight some of the things we've been doing and some of the things we intend to do, including promoting the work that the colleagues here are actually doing right now. Let me see. So just Gaia, can I share my screen, please?
Yeah, let me just enable that. Sorry.
Okay.
Yeah, go ahead. I think you should be able to.
Okay, thank you. So by way of introduction, I actually forgot to mention my name when I was starting the program. So my name is Etim Ofyong. So some people pronounce it as Etim, so anyone works. I'm co-founder of the African Space Leadership Institute. My other co-founders are Dr. Adigun Ade Abiodun, who was a former UN expert on space applications, and Dr. Bolanathan Munsami, who was a former CEO of the South African National Space Agency, and of course, Lulu Makapela also. So I just want to give a brief of the African Space Leadership Institute, and I usually like referring back to the African Space Policy and Strategy, which I also had the privilege of participating in the drafting process. So if you look at the documents, the African Space Policy and Strategy, there are two policy goals. And these documents were adopted by the African heads of states in 2016. The actual process for drafting the documents started at about 2012. So it took about four years thereabouts to complete the drafting and the adoption of the documents. The two key goals in these documents, two policy goals, are to create a well-coordinated and integrated African space program that is responsive to the social, economic, political, and environmental needs of the continent, as well as being globally competitive. And then secondly, to develop a regulatory framework that supports an African space program and ensures that Africa is a responsible and peaceful user of outer space. And as the speakers have spoken, a couple of African countries are involved in space, carrying out different space programs. And what we want to try and see is how to support that effort so that all the activities that go on within Africa are in line with international law, are in line with norms and rules and principles. And of course, that Africa is a responsible and peaceful user of outer space. In fact, this webinar series is actually hinged on this second goal. The webinar series we're having on space sustainability. Okay, sorry. Yeah. So the idea about the Space Policy Institute, actually, if you want to trace a bit of history, it started at about 2016 when I initiated discussions with Dr. Bolanathan Munsami, who was my supervisor at the time. And we started, the idea came based on the fact that we identified some gaps when we were developing the African Space Policy and Strategy. There were some gaps in knowledge about space policy, law, and governance within Africa. And we felt that there was a need to set up an institute, a think tank, to fill up these gaps. And then at about 2018, we kind of put down the ideas on paper to concretize it. And this paper, titled Towards a Space Policy Institute for Africa, it's available online. You can download it and read. And that's actually the guiding principle that we use in our activities so far. Even though we wrote this paper in 2018, the actual implementation didn't start till about 2021, November 2021, where we actually started working on developing the institute. And then by July last year, we registered the institute in South Africa. And then we did a public presentation in October last year. So we actually started full activities October last year. And at this point, I want to say a big thank you to all colleagues, both within Africa and outside, who have been supporting our activities. And we look forward to more support. So, well, you may look at the Institute as having two caps, basically, one as a think tank and also as an institute or educational institute. And we have two core missions, one to support current space leaders. And if you look at what the space leaders do, they make policies, they implement policies, they make decisions, they develop strategies and law and governance. And so we want to support current space leaders in Africa in terms of policy making, decision making, development of strategy, both at the national level, but also at the firm level. As you may be aware, a couple of companies are springing up in different parts of Africa, South Africa, Kenya, Nigeria. So some of these companies, we want to see how we can support them so that they can go international. And then also talking about security, defense, and military, which is one of the activities we are having today. Very important is law and governance. And we are not just focusing on the Outer Space Treaty, but the new norms, the new rules, guidelines that are coming up. We want to see how we can push it within the African ecosystem. The regulatory issues, both at the national level, but also at the thematic levels too. So if you look at the space policy and strategy, there are 4 primary focus: satellite navigation, Earth observation, navigation and positioning, and astronomy. Each of these thematic areas also have rules or governance frameworks. These things are what we want to bring to light within the African ecosystem. And of course, as a think tank, we want to do advocacy and advisory. The other part, which is very strong and we are very passionate about, is developing future space leaders. So we are thinking of educational programs. We are giving opportunity for volunteering. Right now, we have 3 people who are volunteering and working with us. Of course, it's pro bono, but we are supporting them. For example, the volunteers that are currently with us now, we are sponsoring them to the IAC, which is coming up in October. And we are hopefully we have some other means of encouraging more opportunities of volunteering, and then internships and also fellowships. Also, we are currently in talks with the European University Institute to see how we can have the fellowship for EU Africa. I mean, to strengthen EU Africa space relations. But hopefully we'll have some other fellowships in mind. So we really want to do quite a lot of educational work to develop future space leaders. In terms, if you look at it as a bouquet, there are 3 major aspects to what we want to do. One is capacity building, and then 2 is to promote Africa in the international scene. Like the speakers have spoken, Africa's voice needs to be heard in the international community. After this institute wants to play a role, both as a voice, but also to kind of promote other voices also. And then to also do some kind of focusing. Many African programs are not properly channeled, they are not visionary, they are not strong. So we want to also assist when it comes to strategic focus. So we plan to have several programs like webinars, conferences, training courses, dialogues, do a lot of research. From those research, do a lot of publications, and then also establish a library, both a physical library and an online library. So these are some of the things that we have in mind to do. We've already started some of the activities. One of the things we do is policy talks. And the idea about the policy talks is to invite leaders, both in Africa and outside Africa, to talk about global issues, how they affect Africa, and how Africa can respond. Another thing we do is a round table where we bring people from different parts, I mean, different opinions or different parts of the aisle to discuss on different issues. We've had one, which this just came up just before the US-Africa Space Leaders Summit, which was held mid-December last year. And we brought people from the US and from Africa and had a discussion. The other thing we intend to do, so in the African the Institute, we have 8 key values, and one of those values is accountability. But we also want to extend that value into the African setting. So we want African representatives and leaders to be accountable. So when they go for meetings, when they go for different activities, we want them to be able to speak back to the African constituency. So we have this program, View from the Sites, where when there's a meeting, people come to give a feedback. This one that is on the screen now was based on the US-Africa Space Forum, which was held December last year. We are having another one very soon, based in respect of the recent S&T subcommittee meeting. So 2 representatives who attended the meeting in Vienna are going to give a feedback of the deliberations and the outcome of that meeting. So upcoming events, so we plan to have more policy talks. We have an average of 1 every month. The next one is coming up on 22nd of this month, and that is going to be focused on astronomy. We plan to have more space policy talks. That's going to be quarterly. And very importantly is the courses, the educational aspect. We plan to run a couple of courses. For us, we want to focus more on the non-engineering part and leave the engineering courses to the universities. So things that are probably not being taught in the universities, those are the things we want to kind of organize. We have one that's starting up on April 6th, and that's our first course, that's the space policy course. And we have a lineup of facilitators from an international faculty, let me just put it that way. So the applications are currently open. You can check up on the website and register. The Space Law and Governance course is going to start in August, and then the African Space Policy and Strategy course will start in October. So all the programs will be on the website. You are welcome to join any of the courses. And if you have any idea, so the ASLI is actually a platform. So if you have any idea or if you have any initiative and you think we can partner, that would be something very good. We appreciate that. We plan to have more webinars. So when the registrations for these webinars come up, I usually check to know what are the interests of people. And I saw that for the space sustainability, there's still an interest for a webinar on space debris. So we're looking at doing that webinar hopefully next month. Have more programs on view from the side, and of course book talks. I think with that, I'll just stop here. That's just an overview of what we are doing. And I'm hoping to, for us to have more discussion, possibly, of course, definitely outside the program. Thank you for Professor Jaku, and thank you once again to all our speakers. Thank you.
Thank you very much, Mr. Offing, for educating us about your program. It's a very interesting program. You have it, and I mentioned earlier, we extend our hand of cooperation and collaboration and wish you good luck. I'm very impressed by your Pan-African approach, cooperation at home, if I can use the word, and then see cooperation from outside. It's a homegrown initiative, which is I applaud, and then again, wish you good luck. I think that's the way to go about it. So let's go to the question and answer session. Ishit, I was wondering if you can share with us some questions which my colleagues can respond.
Sure, Professor. Good morning, good afternoon, and good evening to everyone. So we had a set of questions at the time of registration. Participants were asked to post their questions before the webinar. There were 3 or 4 questions. We're going to try to address them first and then come back to the ones that were posted by the audience just now. The first question is by Daniel Moss, who asks for the perspective of the speakers regarding the African legal and regulatory framework for space activities, and wants to know any milestones for the African continent as a result of these initiatives, including the manual.
I'll answer that question. I think this is a very, very good, very appropriate, very timely question. And this is why my personal view is on that. Law is a means, very important means. Law is not a goal, but you must have the proper means to achieve your goals. So a regulatory system in all countries, particularly democratic countries, play a fundamental role. It shows the seriousness of a country, that it is serious about space programs. So drafting, adopting, implementing, revising laws and regulations are of critical importance. We know that already a number of countries in Africa, they have their national laws. That's a great, and other countries will be joining that club. Now, there are different reasons for adoption of law, national laws. And first, of course, is really to set your priorities or policies in place, and that you need to allocate funds for that, and also government machinery with respect to regulations and your implementation of international obligations. So this is where Africa is, where Africa should go. This is again my personal a humble suggestion that all countries first, foremost, should consider ratification of all space treaties. And again, personally, I would like to ratify the Moon Agreement, which is not in limelight, or it actually is not considered to be good. But I think one should look at the benefit of Moon Agreement, particularly for African countries. And the legislations should also, if it's already there, that's fine, maybe reiterated. The new legislation in Africa should underline that your space programs will be exclusively for peaceful purposes. That will promote sustainability of space program, and also encourage international cooperation in that. And also I will say there should be some provision in that law that you as a country or a country will be promoting your vision, your version of a policy at international level. So to me, the milestone is, you can have different milestones, but I think the first milestone today in near future is the adoption of the treaties and adoption of laws and regulation with respect to space matters. Now, I have some experience. Again, my colleague Stephen Freeland has tremendous experience in drafting national laws of different countries with respect to space. There's a one word of caution, if I dare to say, that space laws for countries, particularly developing countries, must be custom made. It should not a copy paste from other. What is good for Canada doesn't mean it's good for Ghana, and so those are the things which must be looked at. That, and also I also like to emphasize, which I mentioned to you earlier, that it should be homegrown, custom made, looking at what is realities in your country and that kind of thing. So those are the things. And once you develop that, the laws on the books are not good enough unless they're implemented with the money, and also seeking cooperation of other countries. Particularly, I am a very strong advocate of South to South cooperation, and with an Pan-African cooperation, then getting into international cooperation. So I don't know if I answer your question, but I think it's a very important means for development of space programs in each country. Thank you.
Thank you, Professor. The second one comes from Quinn Newton, who wants to know that in situ resource utilization has long been considered a prerequisite for maintaining a sustainable human presence during future space exploration efforts. But what role does space exploration and space resource extraction and utilization play in sustainability on Earth? Could the responsible use of space resources help us break our over-reliance on terrestrial resources? And what frameworks would make such a state of affairs possible?
Perhaps, Bram, I could answer that question.
Please.
Yes. Thank you for the question. And I think it's an important question. So I answer, as I mentioned, I have the honor of being the co-chair of a working group looking at space resource activities, but I answer now in my personal capacity, obviously. So go back to the law. Article 1, paragraph 1 says that the exploration and use of outer space, amongst other things, shall be undertaken for the interests and for the benefit and the interests of all countries. And when the idea of now perhaps going back over a decade, when the serious idea, I mean, obviously we had the Moon Agreement that Ram referred to in the 1970s, but when the idea resurfaced about in situ resource utilization, the argument was put like this: we will go to, let's talk about the moon, but we will go to asteroids, the moon, celestial bodies. We will, because we understand there are significant deposits of rare earth minerals, of perhaps the isotope helium-3, etc. We will go there, we will exploit, we will bring those materials back, and to the, giving great benefit for their usage on Earth. But also, as the question implies, the assumption was, to the extent we do that off Earth, then we're not going to do it on Earth. And therefore, we will lessen, if you like, the adverse environmental consequences of continually and rapaciously mining on Earth, and instead move those sort of activities off Earth. Now, 2 points need to be made. Firstly, that doesn't work from an economic viewpoint. Those arguments about going up there, and let's talk about the moon, going to the moon, doing all this stuff, bringing it back, and etc. There is no economic, let alone technological case that currently will support that, and indeed will not support that in the medium term, if at all. And so we're not going to go up there and bring back large parts or large volumes of valuable resources. And therefore, we're not going to, in a sense, lessen our resort to terrestrial uses. And instead, what we're going to do is we're going to go up there, if this happens at all, we're going to exploit the resources. But this time, the focus, at least initially, is not on those materials that we would bring back, but exploit resources like water and create perhaps a refueling plant on the moon, convert the water to fuel, use the moon as a launch pad, and off you go. So we're creating this off-Earth economy. And one could argue, but we don't have time for that, whether that meets this criteria of benefits for all. Put that aside, because that's another debate. However, implicit in the question about if we mine off Earth, then we are saving the environment on Earth, even though, as I said, that's not going to happen, means that we are thinking of space as simply a place to exploit. We are thinking of space as simply something that we take from. We are not respecting the ecosystem of space. If you just have that thought process that we are going to go to space and exploit and exploit and exploit and perhaps bring it back, although, as I said, that's for down the future. We may ultimately be able to do that. We may ultimately, although not for a long time. But the frameworks that we need to do that must be such that to the extent we engage in exploitation activities off Earth, we have a clear understanding of the consequences of that, both from a cultural viewpoint, an ethical viewpoint, an economic viewpoint, and an environmental viewpoint, and that we have appropriate safeguards there. Remember, maximum the benefits, minimize the risk, and of course, minimize the risks of conflict. And that's what the working group will ultimately look at. What does the existing framework say about these potential activities? How do we apply that? Are there gaps? If there are gaps, is there a benefit in developing a framework for specific activities? But all of those things, including other things like equitable sharing and a whole range of factors, are relevant. So yes, in theory, we might be lessening our reliance on terrestrial resources, but to get there, we really have a lot of thinking to do about exactly what that would look like from a regulatory and governance framework. I hope that answers the question. Thank you.
Thank you very much, Stephen. Next one, please.
Mr. Gopalakrishnan wanted to know whether the final outcome of the ongoing open-ended working group meetings on reducing space threats through NPG will help space sustainability. And a second related question posed by him today is that whether this manual would be submitted to the UN Disarmament Forum at Geneva and UNGA for adoption and for wider acceptance.
Yeah. So, thank you. I will take the first part of the question. Well, thank you, Professor Jaku. Well, it's too early or too premature to contemplate the final outcome of the ongoing open-ended working group. But already, with or without any outcome, I think it's very healthy and it's very productive for for us to promote and enhance peaceful uses of outer space. For instance, from procedural standpoint, it's not conference on disarmament. It's been done in the UN General Assembly. So first committee. So not only 65 countries, all states and all stakeholders can gather and exchange their opinions. So the stakeholders can understand each other and can construct common understanding what responsible behaviors and what not so responsible, what irresponsible behaviors are. So concrete standard, concrete contents of good, bad practices, behaviors would be clarified in the end. And that discussions, it's not only for open-ended working group, it can be distributed or influenced to other forums and other guidelines, including especially long-term sustainability guidelines, where specifications, its working group is being held now in the STSC of the UN COPIOS, and also, for instance, Hague Code of Conduct against the proliferation of ballistic missiles, for which all countries can participate if they only show their interest to be a subscribing state. So procedurally and substantially, it's very good. And maybe it's not perfect, but certainly multilateralism and healthy environment, and for the common efforts to identify responsible behaviors would be there. So the first part, I would answer only, I answer only first part, and the second part, I would leave to Professor Jaku.
Thank you very much, Suko. The second part is, yes, not only disarmament forum, but other forums we'll try to approach, particularly COPIOS and any forum, international forum, national forum, universities, wherever it is possible. We will start it. We have already started with this webinar. We will continue this kind of presentations on the manual. Yes.
Can I also add something? So we were quite privileged to be invited by the Open-Ended Working Group last year to contribute to their discussions, and it was an opportunity for us to present a draft version of the manual and also several of the rules that were relevant to the work of the working group. And again, as Stephen said earlier, the McGill Manual is an important tool to support these continuing multilateral efforts and dialogue on disarmament, on confidence building, and having a clear understanding of legal concepts and terms will help increase transparency, which all will in turn contribute to the safety and sustainability of outer space.
Thank you very much, David. Nisha, next question.
Nicholas Valley wanted to, this was during Professor Setsuko's presentation. They wanted to know, the previous slide described space as a special area, but it wasn't clear how response to armed attack in from, and through space would be necessarily different under the law. Can you please clarify?
Yes, thank you very much for your very important question, Nicholas-san. And yes, well, not different law is not necessary. Existing laws in I showed last slide would be enough. So because outer space has special characteristics and nature, necessity and proportionality elements would be different if one a state thinks about resorting to the right of self-defense. So the rules are there. So application, how to apply it would matter. So not to answer your question, no different law is not necessary. Thank you.
Thank you very much, Satsuko. We have 2 minutes to go, and we start that. I've seen some questions. The very question I can, short question I can respond to those. One is that when volume 2 will be published, we are expecting its publication by the end of this year. Springer will be our publisher. The second, if there's a possibility for somebody from Africa to make a contribution to volume 2, yes, we can. Please be in touch with us. We'll see how we can get you involved in volume 2.
Just to add on to that, I'm sorry.
Yes.
The website, the McGillManual.ca, is still open, although we planned on stopping the review feedback by end of August. But we have kept the channels open. So if you have any comment on any rule statement, one of the 52s or all the 52s, you can just log on to the website and provide your feedback, and we'll take that into consideration and try to accommodate that into the commentary as well. Thank you.
All right, so we must stop, but I have a few words on wrap up. Actually, I cannot add anything to what my good friend Stephen mentioned. I think that was a brilliant wrap up of the whole session, and I agree with him absolutely. I just a couple of points I'd like to bring to the attention of everybody. That is when you learn or know or read anything about Miramas project, of course, you look at the content, the substantive rules and the commentary, which I mentioned, maybe about 700 pages. But you always keep in mind the process be followed. And that's the neutrality, independence, originality, and objectivity. And that is a fundamental point. So just that we have our contributors, our partners, our members of the group coming from 30 countries from 6 continents. And we have a 33% female in the group. We have a 14 research assistant young people involved in that. We have people from 5 members of the Security Council, permanent member of the Security Council. That's been from China, from Russia, France, and United Kingdom and the US. Now, I'm very happy to see the presence of our colleagues from Russia, Elena Morozova. She made an excellent contribution and still is working very closely with us and making a tremendous contribution. I see Dr. Ranjana Kaul from India. She has done a very good job for us. So what I'm saying, it is an international effort. And also neutral, and I said it earlier. Look for volume 2. We will keep you informed. We will ask our friend in Africa now, Ethan, to publicize when volume 2 will be published. Again, I want to thank you, everybody, starting with my own colleagues. They spent a lot of time and preparing for this and making excellent contribution, explaining the purpose, the scope, the nature, the content of this innovative study, which we have been working for the last 6 years. and also Nishat and Bayard. I cannot imagine anybody more qualified to handle this whole electronic version, and not last. So the list is our colleagues from Africa, the African Space Leadership Institute. Before I close, any one of my colleagues want to say anything? The last message to everybody, please. No? All right, thank you very much for your participation. We have a good participation from all over the world, and we appreciate your participation, and this is for you. There's no point for us to do everything if there's nobody listening to us, and I'm very glad that a big number of people joined us in this webinar. Thank you. God bless you all.
Thank you, everyone.
Bye-bye.
Thank you.
Thank you.
Bye-bye.
Thank you very
Bye-bye.
much.
Thank you very much
Thank you.
for the opportunity. Thank you.